Hello, and welcome to Sikich HR Consulting's presentation on employee handbooks. A few questions to ask yourself. Does your organization have a handbook? When was it written? When was it last updated? What is your biggest concern about your handbook? In many legal cases involving employment, one of the first questions your attorney will ask you is, does your organization have an employee handbook? Why? Because if you're involved in employment litigation, you must be able to prove that you not only have an official policy, but also that these policies have been communicated to your employees, and the employees have agreed to follow them as a condition of their employment. You must have each and every employee sign an acknowledgement stating that they have read and understand the contents of the handbook, not that they agree with the policies. Additionally, an employee handbook is a positive way to increase employee morale. It provides employees with the company's expectations of their performance, and it provides the framework to implement discipline in a consistent manner. Some of the agendas and goals that we hope to accomplish in the presentation today will be the purpose of the handbook, the influence of the NLRB, NLRA, even if you're not part of a union, handbooks defined, the must-haves, FMLA and LOAs, the should-haves, and the nice-to-haves in an employee handbook. So what's the purpose? Handbook is a communication resource. It includes the company mission, values, policies, procedures, and benefits. It limits legal liability. It protects against discrimination and unfair treatment claims, and explains applicable laws. It can be an administrative time saver because it helps orientate new employees and answers questions that arise during employment. In recent years, the National Labor Relations Board has intensified involvement in union and non-union employee handbooks, particularly in relation to these policies. So based on a series of court cases, Wendy's restaurant being one of the largest cases, where prohibitive language has been found by the courts at NLRB's arguments, which places restrictions on employees to engage in protected concerted activities. And this involves their ability to organize a labor union in accordance with the National Labor Relations Act, specifically Section 7 of the Act. It also addresses the laws relative to sharing wages and benefit information, which could now be a violation of the Act if prohibited. Primarily, a source of these arguments rests in the way they are presented in the handbook. For example, they cannot be broad-based restrictive statements. Rather, the policy language should be specific. A guidance memo came out March 18th of 2015 and provides examples of lawful and unlawful language. Some examples are at-will disclaimers, social media policies, conduct and behavior standards, anti-disparagement language, policies restricting after-hours access to work premises, anything saying a company is union-free, policies regulating media, law enforcement, government agency contact, arbitration policies, and so on. This is not a comprehensive list. So what can employers do? We suggest using disclaimers. So a disclaimer could be something such as, nothing contained in this policy is designed to interfere, restrain, or limit employees' communication regarding wage, hours, etc. So you may want to put a disclaimer anywhere that it might make sense. Avoid vague terms, such as sensitive information or embarrassing. No burdensome requirements on employee communication, such as requiring an employee to ask permission before every social media post or requiring an employee to use a disclaimer on every text. You want to try to be as specific as possible. Every employee handbook is a springboard to understanding and meeting expectations, allowing employees to have the information they need to function effectively in their organization. This is a guide to living within the organization. It's a rule of the road. It covers everything from where to park to how to call in absence, appropriate dress, etc. Think about everything an employee needs when he or she starts with the organization. It is also a reference that your employees will refer back to from time to time when they need information. So for example, how much vacation time will I have after 10 years? What processes do I need to take when I have a medical condition that falls under FMLA? It's a guide to how to get things done, whether there's a concern about pay, benefits, or a problem that needs to be solved. It is a supervisory tool. This gives your supervisors ammunition. Supervisors can let employees know about key policies, can also refer back to them when things aren't going right. If someone isn't following the attendance policy, the supervisor can point out to the employee that he or she received a policy and should know what to do. It also provides the backbone of a supervisor's management toolkit. A handbook provides basic policies protection for the organization. The handbook sets forth many basic protections for the organization, in which we will discuss further. There are specific requirements and policies the organization of a particular size must provide to all employees. A handbook is a way to communicate policies to all members of the organization, and it also creates consistencies because everyone is given the same information. Your organization protections help in a variety of ways. They put the organization on record as supporting key employment actors, including equal employment opportunity, at-will employment, harassment-free workplace, and so on. They set a stage for the discipline and termination processes. They set limits for what the handbook is and is not, and they require that employees read and understand what's contained in the handbook, and also help in defending the organization against frivolous employment suits. It is the employment life cycle from hiring to resignation or retirement. A handbook should be clear. We want to make sure your handbook is written so that employees understand. Policies should be clear and to the point. It should be consistent. A handbook should be consistent across the organization. You need to make sure that supervisors understand this. You want to get everybody on board. The term supervisor is referred to at least 46 times in a typical handbook. A handbook should be available. You want to make sure the handbook is given to every employee when he or she starts, as well as when revisions are made. And a handbook sets the tone for your company and aligns with your culture. A handbook is not a one-time attempt to deliver all rules and regulations of the organization. Handbooks need to be updated as policies change and to keep up with ever-changing employment laws. A well-written disclaimer, as well as an at-will statement, clearly states the handbook is not a contract or a guarantee of employment. Procedures are typically found outside the employee handbook. Procedures for employees and supervisors tend to weigh down the handbook and make information difficult to find. They are not a substitute for good practices. Policies are worthless unless management follows them. Further, they are not a substitute for personal interaction. They cannot take the place of one-to-one interaction between management and an employee. And one size does not fit all. Handbooks must be tailored to your workplace. We have created handbooks for companies with as little as 2 employees. It is never too early to begin to outline important company policies and communicate them to staff. It keeps everyone on the same page as you grow. You may think employees know what to expect, but the reality is not always. This puts everyone in one place as a reference point and gives employees a place to refer back to when there are questions. You have an electronic copy of your handbook. It's not too hard to change anything. There should also be a disclaimer about the company's right to modify policies at any time for any reason with or without notice. The must-haves. We call these the non-negotiable items you will need to have in your handbook. These are the must-haves from a legal compliance standpoint. What are those disclaimers? What the employee can and cannot expect from a handbook? They might include a statement such as, handbooks contain important information employees are responsible for knowing. Policies can be changed, modified, or discontinued at any time by the organization. Benefit plans are only a summary. No supervisor or other representative other than the president has authority to enter into an agreement. Or handbooks or any other company document is not to be considered a guarantee of employment or contract. Employment may be terminated at any time. You want to use wiggle room language, such as Generally, we attempt to review your performance on an annual basis. You may want to include definitions of the types of employment, such as full-time, part-time, temporary, seasonal, intern, exempt, non-exempt. You may want to include a statement that the company intends to base all employment decisions on individual capabilities without regard to race, color, religion, sex, age, national origin, veteran status, disability, or other personal characteristics defined by state, local, or federal laws. You should also let people know where to go with complaints. EEO law prohibits discriminatory behavior. Pregnancy accommodation is closely related to leave and anti-discrimination policies. So several states have passed laws requiring accommodation for employees limited in their work by pregnancy, childbirth, lactation, or related conditions. More common accommodations involve more longer bathroom breaks, access to places to sit, limits on lifting, and access to private non-restroom areas for breastfeeding. An important aspect of this act is if an employee does not ask for or does not accept accommodations, employers cannot treat her any differently than any other employee, or they risk triggering the Pregnancy Discrimination Act of 1978. Most laws require notice of rights to be given to employees, and the Handbook is an ideal place for that. And this is considered under federal law. Does your organization have a CDL or other sensitive positions that require special considerations or laws relative to drug and alcohol? How about a prescription or over-the-counter drug policy? This could be included in a section where you address medical marijuana. Registered qualified users of cannabis under the Compassionate Use of Medical Cannabis pilot program, where such program is active and lawful, are required to inform their supervisors that they are taking such medication or substance on the advice of a physician's diagnosis. And the state of Illinois has a legalized medical marijuana program, which allows legal medical marijuana patients to receive marijuana recommendation from a certified physician, apply for state-issued Illinois medical marijuana ID card, and grow and/or purchase marijuana for medical use per state guidelines. In order to become a legal medical marijuana patient, you must first have a qualifying condition as outlined by the Department of Health Services and/or the Department of Justice. The Genetic Information Non-Discrimination Act, or GINA, went into effect on January 10, 2011, but was passed in 2008. GINA prohibits employers from discriminating against or harassing current or former employees and/or applicants based on genetic information and retaliating against individuals who complain. This includes genetic information from family medical history, and it may also include protected classes in EEO statements, harassment policies, and so forth. The Americans with Disabilities Act, or ADA, makes it unlawful to discriminate against anyone because of disability or perceived disability. The EEOC just recently approved the broadening of the definition of disability, which now includes the requirement to notify the employer of a need for an accommodation. The ADAAA, now considered a disability, has been widely broadened to include cancer treatment. Ongoing chemotherapy can now be seen as falling under the ADAAA. Mental health issues are also now included. Pregnancy now falls under ADA, FMLA, Human Rights Act, and so forth. And this includes frequent bathroom breaks, assistance with heavy work, private space to express milk, time off to recover from pregnancy, reasonable accommodations. This involves participation on part of the employer and the employee. And this is just another reason to have updated job descriptions to include reasonable accommodations that point back to the essential functions of the job. A harassment prevention policy should highlight the organization's commitment to a workplace free from harassment. A definition which should include harassing, discriminatory behavior, what it looks like, the organization's commitment to investigating complaints, and where to report complaints. This also includes inappropriate text. Title VII prohibits discrimination, harassment in the workplace. It absolutely is essential for employers to implement an anti-harassment policy, especially in light of two important U.S. Supreme Court decisions in Burlington Industries, Inc. v. Elhart and the Beringer v. City of Boca Raton case. In those two cases, the Supreme Court held that the employer is automatically liable if 1, the unlawful harassing conduct was perpetrated by a supervisor, and 2, the supervisor took an adverse employment action against the employee, such as demotion, discipline, or discharge. However, if no adverse employment action was taken, an employer may raise an affirmative defense, and this is based on 2 critical things. 1, you must show that you have an anti-harassment policy and that you acted quickly and have made a good faith effort to educate employees about the policy. And 2, the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. Again, another reason to have that policy in your handbook. Some other critical policies: employment at will. Employment at will appear several times throughout your handbook and outlines that employment at will, that the employer or the employee can terminate the employment at any time for any reason. Confidentiality. The Illinois Trade Secret Act prohibits all employees, both during and after employment, from using or revealing any company confidential information to a competitor or someone seeking to do business with the company. Access to employee records. Personal Record Review Act states that Illinois employees can request to review personal files up to 2 times per year. The policy should provide information on the process for requesting the file. Other states have different laws, so if you have operations in other states, you should look into those specific laws. And whistleblower. This encourages employees to report any known violation of federal, state, and local laws that discuss confidentiality and guarantees against retaliation. There are also training and webinars available to share with employees that go over employee protections regarding whistleblowing. Social media policies. Social media privacy laws protect employees who refuse to provide employers with access to their personal social media accounts. So please be aware of the NLRA requirements and ensure that policies aren't overly broad or burdensome. Managing required leaves of absence and time off can be quite a challenge for the employer. Having a policy in your handbook that points to these can be very helpful. Let's go over those next. First, family medical leave. Employees are eligible for leave if they have worked for their employer at least 12 months, at least 1,250 hours over the past 12 months, and worked at a location where the company employs 50 or more employees within 75 miles. Whether an employee has worked the minimum of 1,250 hours of service is determined according to the FLSA for determining compensable hours of work. While the 12 months of employment need not be consecutive, employment periods prior to a break in service of 7 years or more does not need to be counted unless the break is considered by the employee's fulfillment of his or her National Guard or Reserve military obligation. This falls under the Uniformed Service Employment and Reemployment Rights Act, or USERRA, or if there's a written agreement, including a collective bargaining agreement, concerning the employer's intention to rehire the employee after a break in service. So a quick snapshot of the family medical leave. Again, you can take up to 12 weeks of leave within a 12-month period. You must define the 12-month period as the employer. You can take leave intermittently as the employee, except under the military caregiver leave, and we will get into that. So some of the reasons for taking FMLA. The birth and care of your newborn and you, time taken off due to pregnancy, complications can be counted against the 12 weeks of family and medical leave. Placement of a child for adoption or foster care. Care of a child, spouse, or parent, considered family member, who has a serious health condition, your own serious health condition that makes you unable to perform your job function. Exigency leave due to qualifying exigency resulting from a covered family member's active military duty or call to active federal duty status. Care for an injured spouse, son or daughter, parent or next of kin, who has incurred a serious injury or illness in the line of duty while on active duty. Note on this one, this is a special leave requirement that allows an employee to take up to 26 weeks of leave. Definition of serious health condition. This is an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment of a healthcare provider. Under exigency leave. Exigency leave provision is quite broad, and it covers both regular armed forces and reserves, meaning duty during deployment to a foreign country, and this changed in 2010. It allows eligible employees to deal with qualifying as exigency arising out of the fact that the spouse, son, daughter, or parent is on a covered active duty or has been notified of all impending calls to covered active duty. So some reasons for exigency leave is short notice deployment, military events and related activities, childcare and school activities, financial and legal arrangements, counseling, rest and recuperation, post-deployment activities, and additional activities. Military caregiver leave. Eligible employees include spouse, son, daughter, parent, next of kin of the covered service member with a serious illness or injury. It includes a veteran who's undergoing medical treatment to recuperate or therapy for serious illness or injury, even if the vet was a member of the armed forces anytime during the 5 years preceding, and may take up to 26 weeks of unpaid leave during a single 12-month period. Under FMLA, an employee who actually has day-to-day responsibility for caring for a child may be entitled to leave, even if the employee does not have a biological or legal relationship to the child. The definition of son or daughter is limited to children under the age of 18 or 18 years of age or older and incapable of self-care because of a mental or physical disability. So some factors to include are the age of the child, the degree to which the child is dependent on the person, the amount of financial support, if any, and the extent to which the duties commonly associated with parenthood are exercised. Employers should be aware of situations that could easily become FMLA leave, so important to start the clock as soon as possible on that 12-week leave. Employee obligations are to, when notify the employer of the need for leave, complete the medical certification, and upon return, to provide a fitness for duty or a return to work. When drafting your Family Medical Leave Act, or FMLA, policy, you should include eligibility reasons for leave, the definition of a serious health condition, definition of in loco parentis, length of leave, paid time off that it runs concurrently, definition of 12-month period, employee obligations, compensation and benefits while on leave, and the process for returning to work. The Victims Economic Security and Safety Act, or VESSA. An employee is eligible for VESSA leave if the employee, spouse, parent, son, daughter, or person jointly residing in the same household is a victim of domestic or sexual violence, and leave is needed for any one or more of the following reasons: seeking medical attention or recovering from physical or psychological injuries caused by domestic or sexual violence, obtaining services from victim service organizations, obtaining psychological or other counseling, participating in safety planning, temporarily or permanently relocating, or taking other actions to increase the victim's safety from future domestic or sexual violence, or ensuring economic security, or seeking legal assistance or remedies to ensure the victim's health and safety, including preparing for or participating in any civil or criminal legal proceedings. So you cannot require a person to use paid time off. You also cannot require the leave to run on a rolling calendar year as you can with FMLA. Those are two very important distinctions between VESSA and FMLA. For military leaves, under the federal military leave, there is no minimum number of employees. The leave of absence without pay will be granted if you are called to active duty for a branch of the United States Armed Services. Generally speaking, employees who return from military leave will be placed in the same position in terms of pay, benefits, and seniority as if the employee had been an active employee throughout their length of military service. Under Illinois law, it provides employees with up to 30 days of unpaid time off with the guarantee of reinstatement to visit with a spouse or child who has been called to military service for a period longer than 30 days. Employers with between 15 and 50 employees are only required to give up to 15 days off. All others must offer up to the maximum of 30 days. Employees must use all paid leave, including vacation and personal days off during this 30-day leave. Some other leaves that we need to consider: the blood organ donor leave. So any government employer or private employer with 50 or more employees, they need to allow employees who have been employed for more than 6 months to have 1 hour paid leave for every 56 days to donate blood, or 2 hours for platelets, and 30 days for organ donation, such as a kidney. But the employee must obtain prior approval. For school visitation, so whether this is public, private, entity with more than 50 employees, again, the employee must be there more than 6 months. They need to allow 8 hours of unpaid time off during the school year to attend educational behavior conferences. This is for grades K through 12. No more than 4 hours need to be allowed in one day, and if taken, the employees must have exhausted all accrued time off except for sick. You can require them to use their PTO, and they must request 7 days in advance, except in emergency situations. Illinois law requires an employee who is to work 7.5 continuous hours or more to be provided an unpaid meal period of at least 20 minutes. The meal period must be given to an employee no later than 5 hours after beginning work. Illinois has no law regarding breaks. The Nursing Mothers in the Workplace Act requires reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth, each time such employee has need to express the milk. Employers are also required to provide a place other than a bathroom that is shielded from view and free from intrusion from coworkers and the public, which may be used by an employee to express the breast milk. The FLSA requirement of break time for nursing mothers to express their breast milk does not preempt the state laws that provide greater protections to the employees. So, for example, providing compensated break time, providing break time for exempt employees, or providing break time beyond 1 year after the child's birth. Paying employees correctly. You will want to have a section in your handbook that addresses how you are paying employees. First, proof of authorization to work. The USCIC requires that all employees have completed an I-9 form and that you have this on file. This is a requirement of employment. Employment status. The FLSA requires the employer to define exempt versus non-exempt. Non-exempt employees are subject to the minimum wage, overtime, and time record provisions of the Fair Labor Standards Act, as well as state wage and hour law and regulations. Overtime should also be defined, which includes any hours over 40 must be paid time and a half. Your policy should state that is actual hours worked. Paid time off does not count, otherwise you may end up paying when someone has paid time off. Comp time is not allowed in the private sector as of right now. However, the law may change here shortly. Paying employees correctly. It's suggested that you also have a section in your handbook regarding improper deductions. Safe harbor provisions from the updated FLSA regulations in 2004 state that an employer needs to let employees know where to report improper deductions. This shows that the employer acted in good faith. Docking employees' pay. There are certain regulations regarding docking exempt employees' pay. There are only certain situations where an employer can dock pay from an exempt employee, and these should be outlined in your handbook. They include violation of major safety rules, disciplinary suspension, first or last week in employment, full day of exhausted all personal time off, if a sickness is covered under any other disability plan, or if there's FMLA time. It's not recommended that you have written policies that state pay is confidential. because this violates the Illinois Equal Pay Act. Now, on to the should-haves. These are the things we strongly recommend you include in your handbook because they begin to set the expectations in a variety of areas. So the workplace basics. A non-solicitation policy limits solicitation and distribution activities in the office locations to non-work times, such as lunch breaks or before or after work, because these activities take away from time that we need to spend with our clients. Non-employees are prohibited from soliciting funds or signatures, conducting membership drives, distributing literature or gifts, offering to sell merchandise or services, or engaging in any other solicitation, distribution, or some similar activity on company premises. That's a good example of a non-solicitation policy. Additionally, you may want to outline hours of operation, work schedule, parking, building access, and acceptance of gifts. There are many other examples as well. It's suggested that you outline an introduction period. This can be anything you would like. It can be from 30 days, 90 days, 6 months. This really reinforces the at-will employment. Reporting absences, dress code, and reporting time are other suggested policies. Another area to consider are outlining your performance reviews, salary reviews, and terminable offenses. Communicating effectively. We recommend policies regarding how employees communicate with one another, specifically how to use computers, email for communication. Nothing is private. The employer has the right to monitor for business purposes, maybe how to download software. Is that allowed? How about employment verification policy? Indicate where employment verifications and references should be directed. According to an October 2008 survey, 51% of employees access social networks at least once per day at work, and many of them did so for an hour or more per week. So despite these numbers and the risk inherent in employees using social networking tools, such as harassment, dissemination of trade secrets for information, and lost productivity, employers have been slow to adopt and disseminate policies for appropriate usage of these websites. That was 2008. Can you imagine what it is now and how often employees are on the web and downloading that information? So social networking and social media address the use of company time. Guidance on what to share on social media outlets, but you need to be aware that not to interfere with the rights under the NLRA. So a statement such as, the employer will not discipline employees for engaging in concerted protected activity is recommended. So further communicating effectively, we recommend when discussing cell phone use and texting to abide by the state and city laws mandating the use of cell phones. So the use of a hands-free or stopping the use altogether, prohibiting texting, responding to emails, voicemails while driving. Hands-free laws while driving really are taking in effect not only in Illinois, but across the nation. And then an open door policy might be warranted within your organization as well. How do you communicate about benefits? We strongly recommend a policy that outlines the type of benefits that you have available, the eligibility period, the paid time off, such as vacation, and PTO, how vacation is accrued, how an employee would request vacation, the holidays that your organization observes, COBRA eligibility, jury duty, is the employee paid for that time? Is it unpaid? Supporting a safe and secure workplace. So we recommend policies outlining protecting their organizational assets, office security, emergency notifications. How are employees going to be notified if something were to happen while they're on premise or outside of normal work hours? And how do they report accidents and fires? What are the procedures? What is your termination process? So it's important to remind employees about policies including at-will, confidentiality, and so on. Do you perform exit interviews? When will they receive their final pay and benefits? How about unemployment? And how about those employees who are retiring and retirement benefits that go along with that? And then we come to the nice to haves. Your handbook should create a great culture. Typically, a handbook will outline the company history and will also give your employees an idea of the mission, vision, and values of the organization. Your handbook should match your culture. If you had a laid-back environment, your handbook shouldn't read like it's dictating the rules. You can still make it fun and also get your important points across. And last but not least, we recommend a handbook acknowledgement. This acknowledgement should be signed, dated, and placed in the employee file. This is your proof that the employee received an employee handbook. We welcome any questions about employee handbooks, policies, procedures. You may reach out to me directly or anybody on the HR consulting team. Thank you so much for your time today.